Welcome friends. Let's we discuss about the article Nature and Scope of the Equal Pay for Equal Work. Under the implementation of the Equal Remuneration Act 1976, which is published by V. Giri National Labour Institute, Ministry of Labour and Employment, Government of India. What is the nature and scope of the equal pay for equal work? Equal pay for equal work is one of the directive principles enshrined in Part 4 of the Indian Constitution. Article 39D of the Constitution provides that the state shall in particular direct its policy towards securing that there is equal pay for equal work, both men and women. But Article 37 provides that the provision contained in Part 4 of the Constitution of India shall not be enforceable by any court, but the principle therein laid down are nevertheless fundamental in governance of the country, and it shall be the duty of state to apply these principles in making laws. Thus, it is basically clear that the doctrine of equal pay for equal work, when governmental decision or policy as to fixation of pay scales of government employees is based on no classification or irrational classification, and it is violation of Article 14 and 16 of the Indian Constitution. Then court is empowered to enforce the doctrine of equal pay for equal work. Our Constitution does not directly state the principle, but while interpreting the Article 14 and 16, which are conjectural doctrine, guarantee fundamental right to equality before the law and equality of the opportunity in the matter of public employment respectively. And Article 32 provides the remedy for the enforcement of fundamental rights. The principle of equal pay for equal work denotes that where all things are equal, that is where all relevant considerations are the same, person holding identical posts may not be treated differently in the matter of their wages, salary, merely because they belong from different gender, race, caste and color etc. If any officer is on same rank and also performs same duties, he or she should be treated equally without any gender discrimination. With the faster pace of development, advancement of modern technology and spread of education among women, which paves the way for the emancipation of women, there has always been demand for equal pay for equal work for men and women workers, as women don't consider themselves inferior to men. The International Labour Organization has adopted a convention on this subject which has been ratified by India. Equal Remuneration Convention of 1951 was adopted by the General Conference of International Labour Organization on June 25th of 1951. In order to give practical shape to the contents of the convention, it was included in our constitutional essence. The Equal Remuneration Act 1976 defines remuneration in section 2G as follows. The basic wages or salary and any additional emoluments whatsoever payable either in cash or in kind to a person employed in respect of employment or work done in such employment, if the terms of the contract of employment express or implied were fulfilled. A typical remuneration package in the organized sector consists of a basic wage, dearness allowances, other allowances, and the house rent allowance. The dearness and the house rent allowances can be different in the offices of the same company due to the different cost of living in different cities. The Equal Remuneration Act 1976 under section 4, which make provisional for equal remuneration, are follows. No employer shall pay to any worker employed by him in an establishment or employment remuneration, whether payable in cash or in kind, at rates less favorable than those at which remuneration is paid by him to the workers of the opposite sex in such establishment or employment for performing the same work or work of similar nature. No employer shall, for the purpose of complying with the provisions of subsection 1, reduce the rate of remuneration of any worker. Where in an establishment or employment, the rates of remuneration payable before the commencement of this act for men and women workers for the same work or work of a similar nature are different only on the ground of sex. Then the higher in cases where there are only two rates, or as the case may be, the highest in cases where there are more than two rates, or such rates shall be the rate at which remuneration shall be payable on and from such commencement to such men and women workers. There is no obligation for employers to recognize the existing 3 or any other digit classification of occupations as set out by the International Labour Organization or the government. Employers are free to classify occupations as they wish, thus rendering it difficult to compare essentially similar jobs. Thus, even if the work of a man and a woman are of a similar nature, job differentiation can be made artificially. For example, a cashier is paid more than an accountant, even if the job content is similar in both cases. The cashier is paid more because he handles cash and his job is classified as more sophisticated. The Equal Remuneration Act 1976 covers all industries, public or private sector, organized and unorganized, and all employees doing permanent, temporary, and casual work. The law covers central, state, and local authorities, hospitals and dispensaries, banks and financial services, educational institutions, mines, provident funds, and other state insurance corporations. The Food Corporations of India and other warehouses, all industries under National Industrial Classifications, Group 1, 2 and 3, power, water and gas generation, trade, transport, water, land and air, constructions, real estate and sanitations, religious, community and medical and personal services. The Act does not cover self-employed workers like unpaid women workers in farming, households, and in the unorganized industries in large numbers. The principle of equality is applicable within an establishment. The law permits wage differences to exist across establishments. The wage differentials can be high across establishments because of differences in productivity, and the capacity to pay may differ widely. Since wages in general are low in India, very often there are de facto equal wages due to the general payment of minimum wages. Thus, the Minimum Wage Act 1948 is of overriding importance in respect to equal remuneration in India. The Act states that the basic wage or day shift payment should be the same for the same or similar work. Thus, men can earn more by working in night shifts, since women, by law, are not permitted to be employed in night shift in establishments other than luxury hotels, airlines, hospitals, and a few other specific places. In comparison of permanent workers, the temporary workers are entitled to fewer allowances for the same jobs, even in government jobs. The Act does not apply in cases affecting the terms and conditions of a woman's employment in compliance with the requirements of any law giving special treatment to any woman, or to any special treatment accorded to women in connection with the birth or expected birth of a child, or the terms and conditions relating to retirement, marriage, or death, or to any provision made in connection with retirement, marriage, or death. There are two main reasons for the restriction in the scope and coverage of the law. The first is that legal requirements are different for different industries and sizes of establishments. For example, the Factories Act 1948 requires that only establishments which employs 10 or more workers and use electric power, or employs 20 or more without electric power, needs to file full returns about the status of their workers for the authorities. Similar differentiations also apply to shops and commercial establishments. The regulations therefore does not apply to the smaller establishments. While they are expected to comply with the law, they seldom do. The other reason for the restricted application of the law arises in connection with the legal machinery, which makes provision for few means of overseeing compliance with the Act. Moreover, workers, their unions, and other public support groups do not bring the matter to the fore, since the need for jobs by the workers exceeds the need to practice gender justice within it. The nature of the labor market, high rates of illiteracy, and widespread poverty prevent such matters from being dealt with by the law. The awareness among the people is very low. The concept of equal pay for equal work is not clear in the Act also.